So once again, thank you all for attending another Chai Chat. My name is Maurice Cotman. I'm the director for the Student Center for Diversity and Inclusion. I want to thank three of my students who, without them, these events wouldn't be possible. Zach, Rowan, and Caroline. Without them, Chai Chats wouldn't be a thing. They wouldn't run, they wouldn't function. So I just want to give a lot of praise to them. And today we have Conor Wigginton, Esquire, and he's going to do a little introduction and we're going to go right into it. Conor, the floor is yours.
Thank you very much, Reese. First of all, thank you very much for having me. So my name is Conor. I have been a PD in Delaware County for the past year and a half. Prior to that, I worked at a very small law firm where we had a very large intake of clients, and the way that we branded ourselves was mychesterlawyer.com. So we had a lot of clients. Unfortunately, most of our practice was criminal clients. So I've been basically doing criminal law for my entire career, and I've learned a lot of things. I've learned a lot of things very quickly in the past 3 years. So I'm just here to share what my thoughts are regarding this major topic. And it's definitely a very big topic, and I feel like it's not talked about as much as it should be. So most of my clients, probably 75%, are from George W. Hill Correctional Facility. So I don't get to choose my clients. It's basically people at the PD's office who can't afford private counsel. And when they cannot afford private counsel, they get a public defender, which is me. So 75% of my clients are currently in prison right now. Having said that, George W. Hill is a for-profit prison. Does anybody know what that is? Has anyone heard of that? Well, that is totally fair. Basically, you have a profit prison, you have a non-profit prison. But the people who own the prison basically profit. It's as basic as it sounds off of the incarceration and the work that is done there. And unfortunately, there are many for-profit prisons that are popping up across the entire country. And George W. Hill is one of those prisons. A fun little fact, half of that prison right now has tested positive for COVID-19, which is just not good. And according to John Oliver, who does Last Week Tonight, this is now popping up across the entire nation. So this is something that's happening. Conditions are not sanitary. And half of my clients don't even have a bed to sleep on. So it's really not good. And unfortunately, it's not just in Delaware County. It's across the country and everything like that. So there's a couple of things that I want to talk about during this presentation that basically impacts directly mass incarceration and why there are so many numbers across the country. When you get arrested for a crime, you see a judge within probably 48 hours, and the judge sets bail. Now, when the judge sets bail, he takes into account many things. He takes into account the severity of the crime, your flight risk, meaning if he lets you out, he or she lets you out, are you likely to show up to court? Are you likely to deal with these charges that you have? Most of the time, bail is set at a number that is over $1,000. We called in the business $10,000 at 10%, $20,000 at 10%. And the crimes really aren't that serious when bail gets set at this number. The issue is there's really not a whole lot of people that have $1,000, $2,000 just laying out. If I theoretically got arrested for a DUI and I didn't have family who I could contact for 48 hours, my bail would probably be set at $10,010. I would have to pay $1,000. Do you know how much happens to people within 2 days of just being in jail?
Conor, can I just ask one question?
Yeah, sure.
Meanwhile, you will only have to pay $1,000.
So in the theory, in this hypothetical DUI, unless you have a lengthy criminal record, it's looked at as a serious crime, but not that serious. So $10,000, 10%, based upon my experience of doing preliminary hearings, I've probably done 500 preliminary hearings at this point. I probably have seen 700 arraignments, which is where the judge sets bail. It's one of the very first steps of the criminal process. $10,000, 10% is always the go-to. I don't know why. I never really knew why. I think it's rather silly. In my opinion, you're innocent until proven guilty. And bail, by theory and by law, is supposed to hold you accountable for showing up to court. That's the only purpose of bail. Bail, by law, is not meant to punish anybody. It's only to hold you accountable for showing up to court. But there's so many judges who don't see it that way, or the way that they do see it is by putting a monetary value on a person. So if they pay $1,000, well, you better show up to court if you have paid $1,000. Otherwise, why would you pay $1,000 if you're never going to show up? Because you get 60% of that money back. Yes, you don't get the full amount back when the criminal process is over. You only get 60% of that money, and the county keeps the rest, but you still want $600.
Yeah, so we had a comment. So Zach asked, why say 10% of 10,000 instead of just saying $1,000? But you kind of started explaining it there. So why put it at a number of any significance if you only have to pay 10%?
Reese, that's a phenomenal question. It's always been that way. It's always been $10,000, 10%, $20,000, 10%. The only time where I've seen a judge not add a percentage on the value of bail is when you have a murder charge, when you have multiple felony charges, and the judge will usually set bail at what's called $100,000 cash, called cash bail. And cash bail means that the number that's set, that's the number you have to pay, $100,000 cash. But usually the charges have to be very, very high, and the judge wants to make an example of those charges because everything is going to show up on the internet when the judge does it. So, but unfortunately, 90% of the time, it's always a percentage of something. It's always 10% of something. So that's not really the theoretical answer. It's just the culture. It's just the culture of how the criminal justice system works. So, but there's so many people who will commit these crimes or allegedly commit these crimes. And if you're in jail for 2 days, even though if it's 2 days and you're able to get the $1,000 after those 2 days, like there's so many major repercussions on your life. I mean, if I was in jail for 2 days and my job found out, I would lose my entire job. Once you lose your job, then you can't pay rent. So you lose your job, you can't pay rent, and it's like you've only been in jail for 2 days. So this is such a consistent issue. Cash bail is one of probably the biggest, if not the biggest reason why mass incarceration is so common throughout the country. Does anybody have any questions regarding that? So just another thing to think about. When my clients are in Delaware County Prison, it's called a prison, but in reality, it's a jail. Does anybody here know the difference between jail and prison? So jail is where you're awaiting to go to trial. If you can't make bail, you're in the county jail. And you're going to be in that jail until you get either sentenced on your trial or you get acquitted for those charges. A lot of times, people will take what's called a county sentence. And a county sentence is anything that's less than 2 years. So if you commit a crime for the first time in your life, it's more likely than not you're going to get a county sentence. It's also more likely than not that you're going to get probation. Is anyone here familiar with probation?
Feel free to unmute yourself or put it inside of the chat box. As a concept, yes, says Melinda.
Okay. So probation is normally for first-time offenders, and you have to basically report to a probation officer. It starts out once or twice during the week, and you constantly have to report one person who basically oversees your entire life. What are you doing? Do you have a job? They can drug test you. And unfortunately, there are so many times where people will violate their probation. And people will violate their probation for the most ridiculous reasons that are out there. If you fail a drug test and you smoked marijuana, you technically just violated your probation. And I want to be clear. You could have committed a crime that had nothing to do with drugs. You can still get drug tested. If you smoked a joint and you've been on probation for 2.5 years and your probation officer goes up to you and says, hey, we have a dirty drug test. You just violated your probation. Where do you end back up? You end back up in jail. Because that's what we call a VOP, a violation of probation.
Caroline just asks, are you able to get a medical marijuana card if you're incarcerated?
Are you able to get a medical marijuana card if you're incarcerated? So this is a pretty new concept in PA. Normally, while you're incarcerated and you didn't previously have a medical marijuana card while you're incarcerated, I have not seen that. What normally happens is if I have a client who made bail and one of their charges is a small amount of marijuana, and you bring a medicinal marijuana card to the preliminary hearing, then you're fine, meaning you can't be charged with that crime. But if you previously don't have that card, you can, it's very difficult to apply for that card once you are in jail. And if you had that card prior to being in jail and those are your charges, you have to rely on your family to bring that card to court. That's one of the biggest things. If you have family support in the courtroom, this is getting a little bit off what we just talked about, but family support plays a ginormous role into bail and how the case goes. So I hope that kind of answers your question. Does anybody else have any other questions? I know that I'm talking not very slow, but yeah.
I do while everybody's still putting, so Carrie just, while everybody's putting in questions, I do have something I would like for you to touch on, Conor, because you said violating parole, probation. You can violate for many different reasons. Can you just give some more examples? Some of the ones that I've heard that are a little bit ludicrous is that if you have any contact with a police officer while you're on probation or parole, you can actually violate your probation or parole, even if that's just a simple conversation.
So what I've seen, at least in Delaware County, and I've been doing what's called a gag non-2. It's a very silly term, but it's basically the hearing that you have after you violate probation. I haven't seen, in my experience, mere encounters, meaning if you just have a conversation with a police officer and the police officer has reasonable suspicion that you committed a crime, but then the police officer lets you go. Normally, what I've seen, that has not violated anyone's probation based upon my experiences in Delaware County. However, if you get arrested for anything, it could be in Delaware County, it could be in Philly, it can be in Florida. As long as your probation officer knows that you've been arrested for something, that's an automatic VOP. That's an automatic VOP, violation of probation. And what happens is you go to these hearings and you're either on probation for much longer, you could be resentenced, your probation could be revoked. So that is what we call the endless cycle of going back to jail. It's a complete endless cycle because if you're in court, you're very scared. You don't know how trial is going to end up. And if you see something that's probation, you're like, well, I don't have to go to jail for anything. Sign me up. But there's so many opportunities to violate that. And the reasons for violation are so minute, which is what gets everyone in trouble and back to jail.
How does that work exactly? If you're supposedly innocent until proven guilty, but if you're arrested, you automatically go to jail because you could potentially be arrested for something that was not at all your fault.
Yeah, so unfortunately, probation is a little different than trial. So if you're just arrested for charges and there's no outcome for those charges. So if you're on probation for a completely separate case, right? You're on probation for 3 years. You get arrested and it's a year and a half into your probation. The mere fact that you're getting arrested is an automatic violation of your probation. Now, what attorneys sometimes do is what we call a continuance of the violation of probation hearing. Well, we want to continue that hearing until the outcome of the other charges, the charges that cause the violations, comes to a conclusion. But more times than not, you're not going to get a very quick outcome of what you've been arrested for. So the mere fact that a police officer had probable cause to write up charges is enough for a probation officer to put a detainer on that person. And it's crazy. Does that answer your question?
Yeah, I guess I'm just sort of
Shocked?
not shocked. I think it was something that I was already aware of, more frustrated, especially as we're seeing, as we've always seen, but we're seeing an increase, at least in media presence right now, of police officers who aren't exactly following the law themselves.
No.
Grappling with the fact that, people who potentially are on probation for something that's minor, if even caused by them to begin with, going to jail for something that the secondary thing may not have even occurred, let alone the first.
You're 100% right. And the endless cycle happens if the probation officer recommends more probation to that client. Well, technically you have a year left of probation, but you got arrested for new charges. So instead of putting you back to jail, we're just going to add 2 more years on that probation. So then you're faced with someone who wants to fight those charges, those new charges. That could take up to months, if not a year. The most recent case I resolved was someone was arrested and had been in jail for 9 months. There's a lot of people, regardless of what might be legally in their best interest, who can't literally afford to go back to jail. And that's why you have this endless cycle.
So Conor, we have 2 things. So Melinda raised her hand, so I'm gonna throw it to her. And then we also have a comment from Tiana that I'll read out after Melinda.
I'm gonna unmute my video since you 2 are brave enough to do it. I'll join that. I have more of an existential question, which I don't know if you can help me with. But it also seems like so much of this is flat, like the knowledge is flattened regarding the system, right? Like we have this idea of all of these causal effects leading to a conviction or not a conviction, when in actuality it is mired in process and language that is super complicated. And so I'm wondering, like, how do you uncomplicate that on your end as a public defender and kind of explain the processes? And like, how can we work to uncomplicate or learn more about the systems and how they operate? Like, do you have any resources that will kind of help explain this technicality and the law, which is written purposefully confusingly?
So, all right, that's a very good question. It's not a simple answer, but I'm going to do the best that I can on the micro scale that I have. I'm a trial attorney right now. There's 2 stages to the criminal process. There's a preliminary hearing, and all a preliminary hearing is there enough evidence for a case to go to the trial level? That's all that it is. And the DA, the Commonwealth, the police, whatever you want to call it, just has to show it's 51% likely that that person committed the crime. Let's say that they meet that burden. The charges go up to the trial level. When I see what the charges are, to uncomplicate the law the best I can, the first thing I look at is it my client versus the police? Or is it my client versus somebody who's not a police officer? Because if it's somebody who's not a police officer, you have to rely on the other person to show up to court. If that person doesn't show up to court, the Commonwealth doesn't have a case because it's what's called hearsay. The DA can't use an out-of-court statement to convict my person unless the victim is dead. There's various exceptions to the hearsay rule, but most of the time, a majority of the time, that person has to show up to court. So you weigh that. That's the first thing that you look for. So you look at the credibility. You look at the credibility of the other person. Does the person who's bringing these charges have a record? And a lot of times, it's a family issue. And unfortunately, things in a family can get heated. When things get heated, the cops get called and charges get filed because the cops see it, well, I don't want to waste my time for coming to do a house call. However, the beautiful thing is people have time to think after months have passed. So that's a big issue. Let's say it's my person, my client versus a police officer. Well, is there body cam footage? And here's the biggest thing, which is part 2 of your question, what can we do to help? There are so many towns in Delaware County that do not have body cam footage, and they're not required to. They're not required to have a body camera, which is awful. Because at trial, if you go to trial, it is the credibility of an officer versus your client. and you have to look at your juries. The way jury selection works is it's by registered voters. That's how a jury pool is picked. And in Delaware County, the majority of juries from a demographic standpoint are white women who are in their mid-50s. Why? Because it's registered voters, which is why getting registered to vote is so important. It is so monumentally important, because if you're registered to vote, you will be picked for a jury and you can decide the outcome of a case. It's so critically important that people register to vote, because then you can be considered for a jury pool. So you have to look at the facts of the case. And if it's officer versus my client, what can you negotiate with versus the credibility of your client versus a jury? And you have to know how to navigate around that. And part of that is picking a jury. Answering your question also, judges at a county level are elected. They're elected officials. It's all politics. Right now in Delaware County, most of the judges are Republican. This was the first time in Delaware County where the Democrats won since 1878. You have to know your county. You have to know your county, and you have to know how your judge works. I'm assigned to a trial team. I'm in front of the same judge every single week. Now, to me, that's very beneficial, because I know how that judge thinks. My judge was the mayor of Chester as a Republican and was in the Republican Senate. So I kind of know how he's going to think if it's an officer versus my client. Before trial even happens, what I like to do is, if I think we can get something suppressed, meaning if a charge was based upon racial profiling, if the officer didn't have probable cause to stop my client, I can file a suppression hearing under the Fourth Amendment. And I say, listen, this stop was wrong. There's no reason why the stop should have happened. And if I win that suppression hearing, I definitely know what to do going forward, because I see, well, this is the DA has an awful case. They don't have a good case. If I lose that suppression hearing, then I go to my other options.
I just want to kind of step in a little bit. Melinda, I want to make a quick comment on something you said, and then if it's okay, I want to go to the comments because they are blowing up a little bit. So I know about 3 different lawyers in my personal life, and each one of them, including like the Conors of the world, told me before that law is its own language in a lot of ways. Like, it really, like, words that mean something in the English language sometimes mean something completely different in law and legality. So studying the law is something that's why they go to school. And that's why a lot of inmates, they study their own cases a lot, because there's things that get missed all of the time. And something that I've learned just in life with a lot of people I know who've gone to trial, gone to prison, or have been found not guilty, is that it's not about always innocence. It's about guilty and not guilty. Innocence is a completely different thing. So learning how to use the law that way is crucial. And I just want to go to the comments if that's okay.
Of course.
Cool. Okay. So Tiana said she said a whole lot. So I would love for people to read that. I'm gonna go straight to her question. There's a clear disparity between when this is given to white versus black when talking about expunging records. So what are the parameters around getting a record expunged?
Yes. This is, unfortunately, a lot of people who are in the system don't know what that is. Let's say you want to get a record expunged for anything. We're going to start really basic. At a minimum, it's going to cost you at least $500 to hire an attorney to expunge a record. $500. When I worked for a small law firm, mychesterlawyer.com, that was our discount for people who we knew. People need to realize that it's going to cost them money to expunge a record. The actual process of expungement is not necessarily a disparity, because it's only procedural. You don't see a judge to get your record expunged. So it's only a procedural thing. So you submit a ton of paperwork to Pennsylvania and Harrisburg, and unless the attorney messes something up, your record is going to get expunged. Now, that kind of goes into, well, what exactly can you get expunged from your record? The criminal justice system has 3 different tiers. Have your summary offenses. Those are like, you have a disorderly conduct. You were drunk in public. You had a little bit of a fight, but like nothing bad happened, but the police were called. Summaries, you don't have a criminal record if you have a summary. It's the same weight as a traffic ticket. And you can get that expunged after 5 years. But you have to wait 5 years. So it's not like you can get a summary and poof, all right, well, I did my deal. Let's get this off my record. No. You have to wait 5 years by the law of Pennsylvania. However, with summaries, you don't have to report that to jobs. That's a big thing. If I can go to a preliminary hearing and I have someone who's a nurse or anything like that in a profession or anything like that, where most of the time they're not going to care about summaries, and you're legally not obligated to report a summary because it's technically not a criminal charge. Summaries are technically not a criminal conviction. Then you have your misdemeanor cases. That's a simple assault. That's a retail theft. Pretty much non-violent crimes unless you use like a closed fist and you're punching. Half of the time you can't get those expunged ever because those are what we call an actual criminal record. If you have a DUI, that's technically a misdemeanor. You have to report those to jobs. And half of the time, you cannot get that expunged off your record. There has to be a special circumstance. The amount of years, I don't know off the top of my head for how long you have to wait for a misdemeanor to be expunged off of your record. Then you have felonies, robberies, aggravated assaults, murder. You will never be able to get those expunged off of your record. I've never even heard of a case where someone had a felony expunged off of their record.
Another question from the group, Carrie said, what percentage of cases go to trial? And I know that's different depending on what level of case is it? 5%.
95% of all criminal cases result in a negotiated guilty plea. Because the entire criminal justice system would collapse. If everyone exercised their constitutional right to have a trial, the entire criminal system would collapse. So really quickly, why take a negotiated guilty plea when you can go to trial? Why take a plea? Because whatever sentence you get with the plea is going to be half the amount of time if you were found guilty, if you went to trial and lost. That's why people take pleas. It's all about rolling the dice and knowing the evidence. And unfortunately, this is a reality, knowing your audience. And I hate to say that because it's wrong, but at the same time, if I can save a client from being in jail and they still have their job, I'm going to most likely advise them based upon the facts. If they went to trial and on the facts they would lose and they could be in jail for 3 to 5 years and not be able to support their family.
We have another question. Can you explain the mandatory minimums in PA and the 3-strike rule?
So mandatory minimums, I believe, were recently abolished in PA. Hold on one second. I actually have a DA in the room. So they're completely getting reformed. So you used to have mandatory minimums, but now they're getting reformed. What we do have are mandatory maximums. And those are really what get taken into consideration when you have a plea. So if you're charged with a misdemeanor, the most you could face is up to 5 years in prison. If you're charged with a felony, the most you could face is up to 20 years in prison. And is anyone familiar with an F1, F2, F3, an M1, M2, and an M3? Has anyone heard that like there are 3 categorizations?
Could you just break them down quickly? Like, I feel like people may have heard some, but feel free to break some of them down.
So you have misdemeanors in one tier. Think about them as 2 big umbrellas and organizational charts. And M1 is the worst misdemeanor you could get, and M3 is the least. M3, the most you could be facing is up to 1 year in prison. And M2, which is like a simple assault, the most you could face is up to 5 years. And M1, which are certain theft crimes, the most you could face is up to 5 years. Then you have your felonies, and there's such a huge, drastic difference between misdemeanors and felonies when it comes to sentencing. An F3, which is retail theft after 3 times, the most you could face is 7 years. F2, the most you could face is 10 years. And an F1, the most you could face is 20 years. Your ag assaults with a deadly weapon, those are your F1s. An ag assault without a deadly weapon, those are your F2s. Certain types of robbery are F2s, but they're totally 2 different groups, but they should really be focused because the difference between a misdemeanor and a felony is drastic if you can get those charges withdrawn. And what happens is, let's say you have an M1. Most you could face is up to 5 years in prison. I go to the DA and we negotiate 12 months of probation. You don't see the inside of a jail cell. That's well below the maximum range if you were to negotiate that type of plea, of course, depending on what the facts are and depending on your client's life. But right now, at least what I know is mandatory minimums are currently being reformed by the Pennsylvania Senate. So because of that, and because I started practicing when that reform started, they have not come up. They have rarely come up when I'm in court.
We have another question. Where can we find more information about which Delco police officers are required to wear body cams?
I can tell you which Delco police officers are not required, which is strictly with the culture of that township. Upper Darby Township has probably the worst relationship with the people in Upper Darby because they're not required to wear body cams, and the police don't have to live in that township. I have to say this again. If you are a police officer and you work in a certain township, and let's just say it's a low-income area where it's a very diverse area, it can be an all-white police force. You don't have to live in that township, which is what contributes to such an off-balance relationship with the police officer and the community relationships that they're supposed to serve. Upper Darby definitely has the worst record. A close second is Chester. Is anyone familiar with Chester? I can't even tell you how many murders have happened in Chester this year. It's a part of Delaware County. When I was working for the district attorney's office, because prior to this, I worked as a DA. I was in the internship program where I could do hearings, and they had court 3 days a week, and the least amount of cases you would see on one day is 40 cases. Now think about how many people have to get arrested in a small city, which is really like a township. If people are from Pennsylvania or New Jersey, you know what a township is. Chester is really just a bigger township. It's by no means a city. If you live in Chester, you're within 5 minutes from the other end of that city. That means 120 people get arrested in Chester every single week. And unfortunately, if you're not required to wear a body camera, it's going to come down to credibility at court, which is why it's so important that the legislator has to write some type of law that mandates townships in Pennsylvania to wear a body camera. But Upper Darby is definitely the worst, and that borders West Philly.
I just also want to add, Carrie asks, how does taking a guilty plea affect someone's record and probability of being incarcerated again?
That's a great question. It's what we call a prior record score. So let's say you get arrested for the first time and you plead to a misdemeanor. You're now going to have a prior record score of 0.5. And I'm going to explain very quickly what that means. If you get arrested for the first time and you plead to a felony, you're going to have a prior record score of 1. And what a prior record score means is the more charges you rack up, the more the sentencing guidelines, the standard range of any crime you commit goes up. So if you have people who have changed their life around for the past 10 years, but they got convicted 13 times prior to that happening, and they have a prior record score of 5, and they are arrested for a simple drug charge, they are not in a good position at all. They're looking at mandatory jail time if you were only to look at the standard range based upon their prior record score. So basically, the more you plead to certain crimes and you are what's called a refelon, you're looking at awful standard ranges. But that's different, though, than a mandatory minimum. I just want to clarify that the standard guideline range of Pennsylvania is the equivalent to the periodic table, but it's different than a mandatory minimum.
I have a private question that came in. Wanted to ask, if you get charged but not found guilty, is there anything that remains on your record?
No, you just lost time. There's nothing that remains on your record. If you're charged with a crime and you're innocent, the disposition is going to be all charges acquitted.
I have a quick question. It's like a little bit of a general question, so it might just be like your perspective in Delco.
Yeah.
You were talking about cash bail and like taking guilty pleas and likelihood of like arrest and rearrest. Can you talk a little bit about how race and income shape the likelihood of having a connection to the criminal legal system in the first place, and like how and the likelihood of like taking a guilty plea and the likelihood of being able to afford bail and like...
As far as guilty pleas, at least in common pleas, the DA sees what's on paper. They see the charges. They see the prior record score. So normally, at least in my experience, the DA will make an offer just based upon what's on paper. But let's back up for 2 seconds. Let's go to bail. When I worked at that small law firm, I had a client, and she was charged with an aggravated assault for trying to stab her husband. She happened to be white. She went from an F2 in that court to a summary plea. I just want to say that she went from facing a maximum of 10 years in prison to paying a traffic ticket in that court. I've never, ever seen a person who wasn't white be able to do that. Ever. Ever. So does race play a major part when it comes to people being pulled over, mere encounters with officers? Absolutely. Yes. 110%. The only time that I've seen where it's not that big of a role is just when you're negotiating a guilty plea with the DA, because everything is on paper. The standard guideline range are on paper. That's the only time where it doesn't play that big of a role. But in the very beginning stages, yes, without question.
In your experience, do you think someone might be more likely to take a guilty plea rather than go through trial based on their past experience of the system, based on maybe the neighbor, like based on their interactions with the?
Yes, the clients who want to go to trial the most are people who have never been in trouble in their life, because they only know what they read about trial, that you can go to trial. The people who have committed 1, 2, 3, 4 crimes want to take that guilty plea if it says the right things, because they've been through the system and they know what the system's like. And it's an unfortunate reality of their lives.
And the other part of Carrie's question is, in your experience, what is the median income of a person who has been arrested and sometimes actually goes through the whole process? And not necessarily a figure, but like where they stand when it comes to higher, upper class, middle class, and lower class.
So I'm going to answer this question just with the basis that all of my clients for the past year and a half failed to meet the requirements of the national poverty line. So all of my clients, based upon their pay stubs or lack of pay stubs, qualify with the public defender's office because they're incapable, based upon their job, of hiring a private attorney. If you have a multimillionaire who runs a 500 Fortune company, they can't qualify for the public defender's office because obviously they have the funds to hire private counsel. You know, so based upon that though, it costs a lot more money if you don't have a public defender to go through trial. You have attorneys who will charge $2,500 just to do a negotiated guilty plea. Just think about that. All that attorney has to do at the trial level is maybe appear twice, they negotiate a guilty plea, maybe keep you out of jail, and you pay them $2,500. That's insanity. That's crazy. I would be a multimillionaire if that was my fee at the PD's office. But trials, it's so hard to do a trial without a public defender if you are of low income standards, because trials cost a lot of money, and even a short trial, a bench trial, you're looking at $10,000. Do you know how much you could do with $10,000? It's crazy to just think about that concept, that it's your life and you have to pay someone $10,000 to assert your innocence. But as far as people being poorer or richer and going through the process, I don't think that comes into play. I think their prior record score comes into play a lot more than their financial needs, at least in working at the public defender's office.
To piggyback off that, we have another comment. Do you know the percentage of people in the criminal legal system that require a public defender?
I don't. I don't know the percentage off the top of my head. All I can say is, when I was at the preliminary hearing level, and we're assigned to certain townships. So I was assigned to Darby Borough, Upper Darby, Glen Olden. I don't know if people are from Delaware County, Springfield Township, and Upper Darby again on Fridays, because Upper Darby has court 4 times during the week. Let's say there's 60 criminal cases, and you're in Upper Darby. 45 of those 60 cases have a public defender in that court. But that's just a personal experience. So
I want to say that we have about 2 to 3 minutes left in our session today. Delco poverty rate is 10%, says Jayana. If anybody has any last minute questions, comments that we want to try to add in towards the end, but we're about to close up shop here. So if anybody has any last minute things they would like to say, feel free to unmute yourself or put it inside of the chat as well. Of course, the recording will be available after this. I'll send out an email to everybody who registers for any of our chai chats with the recordings of our chai chats as well. And you can send them out to other people. And by the time the fall term starts, we will have a little media library up where people can access them even if they didn't register. Thank you. There's a lot of thank yous coming in. Conor, I want to thank you for your time. I know you're busy.
Oh, of course, I'm more than happy to be here, and thank you guys very much for having me.
And I also want to thank the DA that you are in the room with, who helped you out a little bit. I know that. So I just want to appreciate everybody. Thank you again for coming. I think this was an amazing conversation. And once I send that email out with, Conor, if you want, I can leave people your information, if that's okay with you.
Sure. Absolutely. Yep.
Awesome. I'll leave Conor's information in the email with the recording. And if you have any other questions or comments, feel free to respond to those emails. Thank you all. Please have a safe night, and I'll get you this recording as soon as I can.
Thank you guys very, very much.
Always love to see who's left after a do. I'm one of those people. So Conor, I want to introduce you quickly to Zach and Rowan. Caroline was in there earlier.
Hey, Zach, how are you?
Good, how are you?
Hey, how are you?
How are you?
Thank you so much. It was great. I love.
Oh, of course. I'm more than happy to be here. Thank you just so much for having me.
Yeah, thank you.
And
Do you guys have any questions?
No, I mean, I asked the ones that I had, so.
Yeah, that's there's just so much information that you need 3 years of school to learn. There's so much information that goes into everything, and I wish the answers sometimes could be more simple, but.
So where did you work before again?
MyChesterLawyer.com, Jackie
Okay.
Jones. And I actually